you're basically saying there's no possibility that we can reach an agreement that I can live with. And the better path forward on this is to bring in a complete stranger who has nominal training in knowing what's best for children.
Yeah.
People will mix custody and placement interchangeably, and they actually mean very different things in the law.
That could be either known as primary placement or sole custody. It's kind of blending both of those together. Well, hello and welcome to the Wisconsin Family Law Insider. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. We are an exclusively focused family law firm here in Wisconsin, and I have with me my co-host today, our managing partner, Holly Mullin. Holly oversees our entire legal team, paralegals, legal assistants, all of that. So welcome, Holly.
Hi, Jeff. Thank you for having me.
You know, Holly, in so many of our cases, one of the biggest issues is custody and placement of the children. This is such an important, significant issue with a lot of emotion and a lot of detail involved. And what I would love to do today is let's walk our listeners through a high level overview of how a judge or how the courts would ultimately help parties decide these issues of custody and placement.
I always tell my clients it's the most important topic of their case. If their case
Mhm.
involves kiddos, we tackle that first. It's the most important piece of the puzzle. So
Mhm.
let's start by just making sure the language isn't confusing anyone, right? So I hear the word custody misused all the time. People will mix custody and placement interchangeably, and they actually mean very different things in the law. So
Mhm.
when we talk about custody, that's the right of a parent or a guardian to make major life choices on behalf of a child. That's custody, right? And so when I'm saying major life choices, that's relating to religious upbringing,
Mhm.
what school district they'll be enrolled in, if they can have a non emergency medical procedure performed, if they can get a driver's license or a passport, right? Like those are major life choices for a child. We're not talking about what's the child's bedtime at mom's
Yeah.
house versus dad's house, or how much screen time do they get? Do they
Yeah.
take hot lunch or cold lunch today? Like those are routine decisions. Major life choices, that's custody. And with custody, you can have joint custody where
Mhm.
both parents together are making those decisions. They are sharing information and deciding together.
Yeah.
Sole custody, on the other hand, is one parent's unilateral right to decide. So, very different than placement. Okay. When we talk about placement, that is the physical schedule. It's where the child is, what parent is physically caring for the child. Okay.
Mhm.
So, we're talking the schedule, that's our placement arrangement. People will say to me, I want primary custody. And I say, that's not a thing.
Yeah.
So, um,
That could be either known as primary placement or sole custody. It's kind of blending
yeah,
both of those together.
exactly.
Yeah.
And they can be different, right? You could end up with primary placement and joint custody.
Yeah.
It's like you could have sole custody and shared placement. So it's these things
I mean,
can be
you could even split up the decisions. Like one parent could have the religious part, the other one can have the education part. There's a lot of ways you can slice this up.
absolutely. And we could have an hour long conversation on this. There's something called ultimate decision making authority where it's like
Mhm.
the parents are required to at least try to reach an agreement and exchange, options. But if they
Mhm.
absolutely cannot agree, then one parent kind of gets that veto or
Yeah.
trump authority to say, we can't decide, so this is my selection.
Yeah.
But but they don't get to just unilaterally decide that without exchanging the information and the options.
Mhm.
So yeah, custody is that decision making authority, whereas placement is time with the children.
Yeah. And it's important for parties going through divorce to really understand those terms because they're going to hear the court say them. So speaking the language of the court is real essential for them to understand that those are the issues. Okay, moving on though, the parties are unable on the onset of their case to reach a mutual agreed upon decision on those two issues, custody and or placement, how does the court typically respond to that early on?
Yep. So, like I said at the beginning of our conversation today, is we tackle this first. So, custody and placement is something that the courts want to make sure that we either have an agreement or we are progressing the case towards an agreement or towards resolution as it relates to the kids.
Mhm.
So ideally, the parents can agree. That's all. That's what the court wants. They want the parents to make decisions about their own children as opposed to having to impose the decision on them.
Mhm.
Uh, Unfortunately, it's not, it doesn't always work out that way. And the parents
Right.
simply cannot see eye to eye on what the terms of custody and placement are going to be. And so, one of a statutory, meaning like the law requires that parties who cannot agree on custody and placement participate in mediation. So,
Mhm.
mediation is where the court requires each parent to meet with a neutral mediator. So, that mediator could be an attorney, it could be a social worker, it could just be anyone who's trained in negotiation skills, but they're there as a neutral to try and help the parents reach an agreement on custody and placement. So
Okay.
they're required to participate in that. Under very, very rare circumstances, the court might allow parties to bypass mediation, meaning skip it,
Mhm.
but that would
Yeah.
be limited to like domestic violence cases, right?
Yeah.
In your standard case, you're going to have to participate in mediation because the court is going to try to get you to reach an agreement.
Yeah.
If that fails, if you participate in mediation and you still don't have an agreement on custody and placement, then the court will appoint a guardian ad litem. And,
Mhm.
some of our listeners may have heard of a GAL,
Yeah.
guardian ad litem. It's really just another attorney who's appointed by the court as a
Mhm.
neutral to do an investigation as to what's best for the kids. So
Mhm.
they
I
are
wanna
going.
back up before you explain that, 'cause I that's you're getting some really good stuff, but on the mediation, I think there's a couple more things that are real important to point out. The mediation, is has a modest success rate, doesn't it, of helping the parties get to an agreement in terms of a fair amount of clients will go through that and then resolve everything at that juncture. Is that right?
Yeah, I mean, when the court appoints a mediator to conduct these, often these mediators are either very skilled family law attorneys or they are in-house, like county employed social workers who
Mhm.
are, I mean, they've dedicated their careers to really helping families resolve issues with their kids. And I think it becomes pretty real to these parties at that time, right? That they're sitting down with somebody having to talk about their kids and they're realizing like, look, I'm going to start engaging like perfect strangers into our family affairs. Like
Yeah.
people, if we can't figure this out, they're going to come to my house. They're going to talk to my kids. They're going to talk to my kids' teachers and doctors. And that just starts feeling pretty invasive.
Yeah.
And these mediators can actually be very good uh, devil's advocates, starting to
Mhm.
kind of shine, like, how do you think that's going to play out in court? Or, gee, it really sounds like both of you were very involved parents. Why are you now seeking primary placement? I mean, it's like they
Yeah.
can really kind of help parties get to a reality check on, do you have reasonable grounds to be asking what you're asking for?
Right.
And they can also find creative solutions, like find some middle ground that these people maybe they dug their heels in way too fast without
Mhm.
recognizing there was room for compromise. And
Yeah.
these mediators can be very skilled at finding some of those ways to bridge a gap between the parents to help them come to an agreement. So, I mean, yeah, if it was no chance of success, the courts wouldn't mandate it. But we see a lot of success in mediation.
And a lot of times too, what I've seen is they'll have partial success. They'll agree, like they go in with 10 issues and they come out with 2 or 3 big ones, which helps narrow the amount of work that's remaining in the case to help the parties resolve it and move forward. So that there's partial wins as well, rather than just a full win sometimes at these mediations.
Yep,
Now, in terms of the
absolutely.
cost of this, is it split between the parties or does the county pick up the tab? Who pays?
It depends on the county. So, if Waukesha, for example, you get one free one, which is great. I mean, these are exceptionally skilled social workers, and they'll let you each try this. You get one for free. If
Mhm.
you found it to be fruitful, but maybe you need a little bit more time, you can pay for a second one.
Mhm.
In other counties, they may not have courthouse employed social workers, so you have to engage a private mediator.
Mhm.
Usually when the court orders mediation, it is typically a shared cost because
Yeah.
they want both parties invested in this. If only one party's paying for this, it just, you need buy-in from both. If this is a worthwhile endeavor to both of
Hmm.
you, and it really, I think, does change the dynamic of engagement. So usually if there is a cost, it will be shared equally by both parents.
Okay, so the parties go through mediation, and for some reason they're not able to reach an agreement, and they go back to the judge and say, "Judge, we can't reach an agreement." How does the judge respond in that type of scenario?
So at that juncture, the court will appoint a guardian ad litem.
Okay.
And that's, the GAL is an attorney, especially trained attorney. And by specially trained, I mean they have to go through a couple hours of training to obtain a guardian ad litem certification.
Hmm.
And they have to keep up with certain continued legal education credits every year to continue taking guardian ad litem cases. But in all reality, I mean, I used to do guardian ad litem work. The training's pretty nominal. I would have
Yeah.
never considered, I mean, I was a guardian ad litem before I had children, and I think I had, it was like 4 or 8 hours of guardian ad litem training. And suddenly I'm being appointed by the court to investigate families and make a recommendation to the court about what's best for these kids. And if that sounds scary to people, it should. It really should
Mhm.
sound scary because you're basically saying there's no possibility that we can reach an agreement that I can live with. And the better path forward on this is to bring in someone, a complete stranger who has nominal training in knowing what's best for children. I mean, they might be a great parent or they may have had years and years of
Mhm.
GAL experience, or they could have been like how I was 17 years ago, fresh out of law school with a GAL certification. And I'm out there I'm gonna tell parents what's best for their own kids. And so, you should look at that as a pretty extreme path forward. And then that process starts. Once it starts, it's underway, meaning that guardian ad litem is going to start asking for either you or your attorney to authorize communications. Like as a guardian ad litem, I used to, for example, seek out certain records. Like if
Mhm.
there was accusations of mental health issues or substance abuse or domestic violence, I might go and look for, criminal records, or I would ask for authorizations into a person's medical history. I certainly want to talk to third parties who are closely engaged with the children, like their teachers or therapists or pediatricians. I may want to talk to third parties like grandparents, um, daycare providers, but you
Yeah.
really are kind of digging into the private lives of these parties to get an understanding of historically here what was going on. How were these parents engaged with the kids? And I'm trying to get an understanding that the best that I can.
Yeah. So the guardian's job is not as a lawyer for the children, right? It's their responsibilities are more nuanced than that. Can you talk to that?
Yep. So it's a gray area, I would say, but a guardian ad litem is not the child's lawyer. They
Hmm.
are appointed by the court as an advocate for the child's best interest, right? And children don't always know their own best interest. Take a teenager, for example. So you have a 14-year-old who can state what they want, but they may express to the GAL, I want to stay at mom's house because she doesn't have a curfew and she doesn't take my cell phone away when I go to bed, right?
Yeah.
That may not be, but this kid might be truant. They might be into drugs or, like underage drinking issues. And I'm going to look for a parent who I think is actually going to impose stricter rules and guidelines for this kid because
Hmm.
that's better for the child. The
Right.
child doesn't necessarily know that. So, like, the difference there is pretty important. A lawyer for that child would be there advocating for whatever the child wants. Whereas, like, a
Hmm.
guardian ad litem is there to advocate for that child's best interest, which may or may not be actually what that child wants. One of the factors that the court is required to consider is the wishes of the child, but it's one
Hmm.
of 14 factors, right? Like,
Yeah.
it's not the only factor.
Yeah.
Uh, so it's one of many that the court will consider and that the GAL should be considering in their investigation and ultimate recommendation. But
Right.
It's not the end all be all. There's a big
So
difference.
that's a good segue to the factors, the best interest factors. This is really the nuts and bolts of a custody and placement dispute is the best interest. So without going through all 14 factors, but just kind of, if you would, describe what they are and how litigants should use them if they go through this sort of case.
So the broad ones, right, are wishes of the kid
Hmm.
and any agreements of the parents. We usually will defer to the parents. If they can reach an agreement, we're not going to even try to impose something on them.
Yeah.
Um, it is going to be, is there any history of substance abuse? Is there a history of mental health illness on either parent? Is there a criminal record? And this would apply to not just each parent, but like who are the third parties that the parents are closely engaged with? Like if they get a roommate who has a litany of felonies, like that's going to
Yeah.
impact their case.
Right.
If there's any history of domestic violence or abuse, like that will
Hmm.
play into this. They're also going to look closely at the relationship, like what's the history here?
Hmm.
What was the parent child relationship leading up to this case? That's really important.
Hmm.
It matters if somebody was quite absent for a long time and now suddenly they want to become engaged. How does that affect the child? What's the child's
Yeah.
attachment to each of the parents? Are there siblings involved or step siblings involved that would be impacted? That this child's relationship with these siblings might be impacted based on the placement schedule. So it's pretty broad. And then of course there's like a catch-all of and anything
Yeah.
else that the court deems
It's
relevant.
important. Yeah. What are some other options the court has in addition to the guardian ad litem to get more insight on the family, the children, and their best interest needs?
Yep. So while I said earlier that guardian ad litem is an attorney who's there
Hmm.
to advocate, if a case progresses far enough, and again, it's really county specific because each county has their own set of local court rules about how they
Yeah.
will handle this. But oftentimes, if a case is likely to proceed to a hearing where a judge may actually have to decide on this, they will appoint a social worker. And the primary difference, I mean, it might feel like the social worker's doing like the same thing as a guardian ad litem because suddenly
Hmm.
they want to interview the parents and they want to talk
Yeah.
to the child and they want to start talking to these third parties who know the relationship with the child. But there's a really important difference, and that is that a social worker is there really to provide like expert testimony. They're a witness in a case.
Hmm.
A guardian ad litem is a lawyer. They're there
Yeah.
to bring evidence into court and convince a court of what their theory of the case is, whereas a social worker is there to talk about their findings and
Yeah.
express, what they believe is best for these children based on what they have themselves seen and heard.
Hmm.
So that's a big difference there. So like a
Yeah.
social
That is
worker is
big.
a witness.
So if two parties are unable to reach an agreement after the guardian ad litem has got on board, after a social worker has done a full study and workup, if they're still unable to reach an agreement, the case will then proceed to a trial where, like you were referring to, where the judge will have a hearing and then make a decision on that. Um, is that the right way that these things are usually resolved if the parties are unable to reach an agreement?
So, I mean, that is how it goes, right? If they absolutely cannot reach an agreement, I'll tell you that's pretty rare, right? I
Yeah.
mean, we don't see a whole lot of cases actually going to a contested trial. I don't have the specific percentage, but I think you could safely say that when it comes to a full blown divorce having to go to trial and let a judge decide these issues of custody and placement, you're looking at 5% or less, right? It's
Yeah.
not something that people usually want to roll the dice on and let a court decide what's going to happen
Mhm.
with their kids. So ultimately, though, yeah, the answer to the question is that is how it would be
Yeah.
resolved. If the parties absolutely cannot reach an agreement, people, it's what you see on TV. You go to court.
Yeah.
And unfortunately, you're slinging mud. You're trying to shine your best light on yourself and make the other party, show how they're not a good parent. You're the
Yeah.
better selection here. It's not pretty, but that's what happens in custody and placement litigation.
Well, Holly, you've done an amazing job taking a very complex set of procedures and boiling them down to a real simple timeline to follow. One last in closing, could you just real quick describe How long does this take? And this sounds like it's a lot involved, but typically, what can clients expect this timeline to look like?
So the mediation, what we talked about earlier, where the court would require the parties to attend mediation, I mean, you could see that happening fairly quickly. I mean, that might happen in the first 60 to 90 days of a case. Getting a guardian ad litem would maybe happen about, let's just say, about 30 days thereafter. So mediation fails and you then have to ask the court to appoint a guardian ad litem. So now you're another
Mhm.
month past that. The guardian ad litem investigation could take months and months.
Mhm.
Candidly, I mean, it wouldn't be uncommon on a contested custody case. I mean, especially if you're getting a social worker involved, I mean, you could
Yeah.
easily be looking at beyond a year.
Wow.
I mean, again,
Yeah.
it is county specific. Certain counties expedite these. I mean, you would see that Kenosha and Waukesha are going to move those to trial a lot faster than like Washington County or Milwaukee County.
Yeah.
Those are going to be very delayed. I mean,
Yeah.
almost certainly if you have a custody and placement dispute and you need a trial date, those are going to be beyond a year, almost
Wow.
certain.
Yeah. Well, thank you. I appreciate you sharing all this with us today.
Yeah, you're welcome. Thanks for having me.
Well, thank you, and I hope that you found value in this video today. And if so, please feel free to go to our YouTube channel. We have a bunch more videos helping clients just like you understand the full process for a divorce.